Presenting the annual Judiciary Report. The report will shine on the spotlight on the performance of the various courts in South Africa. 2021 was a challenging year for the judiciary, with the pandemic seeing courts closed due to COVID protocols and adaptation to allow for remote hearings. The Apex Court has also seen some retirements, leaving some seats vacant. Let's take you there live.
Divisions of the High Court had a total of 11,413 criminal cases, and they finalized 9,749 of those cases. That translated to 85%. That was a great achievement. They exceeded their target. They had set for themselves the target of 64% finalized civil matters. They had a total of 83,080 civil cases and finalized 69,908 of those cases. That translated to 84%. That means that divisions of the High Court exceeded their target by 20% in this regard. That was a pleasing performance. They also set for themselves the target of reducing the percentage of criminal trial backlogs to 30%. They were not able to achieve this target, but they reduced the percentage of criminal trial backlogs to 41%. They were 11% short of their target. Specialist courts. The Labour Court and the Labour Appeal Court had set for themselves the target of 58% finalized labor matters. They were unable to achieve that target, but they achieved 52%. They had 4,168 cases and finalized 2,188. The Land Claims Court had set for itself the target of 60% finalized matters. It had a total of 149 cases and finalized 108 of them. That translated to the achievement of 72%. That was 12% above the target. The Competition Appeal Court had set for itself a target of 85 finalized matters. It had a total of 10 cases, and it did all of them, and therefore achieved 100%, which was 15% above the target it had set for itself. The Electoral Court had set for itself the target of 90% finalized matters. It received a total of 9 cases, all of which it did, and therefore achieved 100% of finalized matters, which was 10% above the target it had set for itself. A reduction of criminal backlogs in the divisions of the High Court. All the divisions of the High Court had set for themselves the target of reducing their backlogs of criminal trials to 30%. However, many of the divisions failed to achieve that target. Only about 3 divisions of the High Court managed to reduce the backlog of criminal trials. reserved judgments. All superior courts had set for themselves the target of 70% finalized reserved judgments. They collectively exceeded this target by 8% and achieved 78 finalized reserved judgments. The superior courts had 4,526 reserved judgments, and they delivered 3,511 reserved judgments within 3 months. The leadership of the magistracy for both the regional courts and district courts identified and adopted performance indicators which will allow reporting on the court performance of the magistrates' courts. This was a significant step in ensuring that the judiciary as a whole accounts to the public for its performance and also allows the head of each court to manage court and judicial performance to ensure the efficient and effective running of the courts. For the collection and collation of the performance information relating to the magistrates' courts, the judiciary relies on the integrated case management system of the Department of Justice and Constitutional Development. As a result of the well-known and most unfortunate system failure caused by an ICT security breach in the Department of Justice and Correctional Services, the leadership of the magistracy resolved that the performance information for the reporting period should not be published. The heads of the superior courts supported this decision as the accuracy of the performance information could not be tested. Gender transformation in the judiciary. We have made substantial progress in the gender transformation of the judiciary, but we have not reached the right level of representation of women in the judiciary. At the end of the reporting period under review, the establishment for judges comprised 234 judges in active service. 44% of those judges are women. The number of magistrates in active service is 1,726, of which 49% are women. Judges discharged from active service. 11 judges were discharged from active service during the reporting period, and no judges resigned. No new appointments were made during the reporting period due to the fact that the Judicial Service Commission could not conduct interviews. There was, as a result of the lockdown measures implemented as part of, this was as a result of the lockdown measures implemented as part of the declaration of the national state of disaster in response to the COVID-19 pandemic. Judicial education and training. Continuous training and development of our judiciary is essential and is undertaken by the South African Judicial Education Institute. A total of 123 judicial education courses for judicial officers were conducted during the period under review. And the causes were attended by 3,297 delegates. Due to the country's lockdown and related regulations, the OCJ had to leverage new technologies by conducting some of these educational courses virtually as a measure to ensure continued judicial education. Sadly, 10 judges also passed on during the reporting period. We remember our departed colleagues and we thank them and their families for their service to the people of this country. Gender-based violence. Before I conclude, let me say a thing or two about gender-based violence. Every year during the Women's Month, namely August, or during the 16 days of activism against violence against women and children, there is an incident that seems to remind us of how just horrific and dangerous this country has become for women and children. And that makes the promise and purpose of both these two periods feel depressingly hollow. This year, it was the murder and dismemberment of Ms. Nosicelo Mtebeni, whose boyfriend murdered her after flying into rage because of texts he had seen on her phone. He believed the texts, which read, "I love you and I miss you," were from another man. It wasn't until weeks after his trial had started that he realized that these were texts he had sent her months before her brutal murder. In 2019, again in August, it was the shocking and terrifying murder of 19-year-old Uyinene Mkhwetyana in broad daylight at a post office. When the lockdown was implemented in March 2020, women's advocacy groups raised the possible impact of having women and children locked into their homes with their abusers. Indeed, shortly after the lockdown began, several Southern African countries noted a significant uptick in the frequency of the domestic violence calls into hotlines and police stations, as well as deaths related to GBV. A pandemic within a pandemic, as described by Mrs. Gracia Machel. However, even those fears could not have predicted the report of the Gauteng Department of Health, also delivered during Women's Month, that girls between ages of 10 and 14 had given birth to 934 children between April 2020 and March 2021. Some of those pregnancies would have occurred during the lockdown when these children of school-going age were at home. These statistics raise disturbing questions about who the fathers of those babies are and when and how these children fell pregnant. We must work much harder than we may have done up to now to implement agreed upon measures to deal with gender-based violence. The Judiciary of South Africa will ensure, as it is required to by the Constitution, that where it deals with matters relating to gender-based violence, it does so in accordance with the Constitution and the law of the Republic. But the attitudes and views that create a culture that condones, normalizes, and justifies violence of any kind against women and children runs through the very fabric of South African society and culture. The Constitution envisions a different kind of threat that must run through our society, that of human dignity, the achievement of equality, and the advancement of human rights and freedoms. These values are fundamental to our democracy. Until women and children can freely and fully be free from all forms of violence that strip them of their dignity, their equality, their human worth, and their freedoms, our democracy is not complete. Earlier on, I made the point that as the judiciary, we understand very well that we derive the judicial power we have and exercise from the people of this country who have given it to us through the Constitution. On Friday last week, our Constitution turned 25 years old since it was signed on the 10th December 1996. It is this Constitution that in section 165 provides as follows, and I quote, 1, the judicial authority of the Republic is vested in the courts. 2, the courts are independent and subject only to the Constitution and the law, which they must apply without fear, favor, or prejudice. Close quotes. Our courts are the guardians of our Constitution. I believe that over the past 25 years, Our courts have done very well in the performance of their role as the guardians of our Constitution. This has sometimes attracted serious attacks against the judiciary. Indeed, over the past 25 years, there have been various storms that the judiciary has gone through, but it has managed to play its role to protect and uphold the Constitution and the rights contained in the Bill of Rights. We do not know for certain how the next 25 years will be, but there is one thing we know. It is that the courts and the judiciary must continue to protect our constitutional democracy for the next 25 years and beyond. In this regard, I'm reminded of what President Mandela said about the Constitutional Court and democracy on the occasion of the inauguration of the Constitutional Court on the 14th February 1995. President Mandela had this to say about the Constitutional Court and democracy. The last time I appeared in court was to hear whether or not I was going to be sentenced to death. Fortunately for myself and my colleagues, we were not. Today, I rise not as an accused, but on behalf of the people of South Africa, to inaugurate a court South Africa has never had, a court on which hinges the future of our democracy, close quotes. All our courts in the next 25 years and beyond will be required to continue to defend the Constitution, to uphold the Constitution, to protect all the rights in the Bill of Rights, to protect judicial independence, to protect the rule of law, even under difficult circumstances, when they may suffer attacks of all kinds. Nevertheless, the times that lie ahead for the country and for the judiciary will require a judiciary that is strong, a judiciary that is determined to protect our constitutional democracy, even under difficult circumstances. I am satisfied that the judiciary that we have will be up to the job. It has been an honor and a special privilege for me to present the Judiciary Annual Report for the period 1 April 2020 to 31 March 2021 to the people of South Africa. Thank you.
Yes, thank you, Acting Chief Justice. We now move over to the question and answer session, which will be facilitated by the spokesperson for the judiciary, Mr. Nube. Over to you, Mr. Nube.
Thank you, Judge President Leo. Colleagues in the media, we are going to open the floor for the question and answer session. I must hasten to indicate that because this session was meant for the judiciary to account to the public, we have then allowed the members of the media who represent the public in this instance to ask the questions on the behalf of the media. I am advised that other stakeholders will have a different session at some point if there is a need to ask questions. So this particular session is specifically for the public represented by the media. I'm requesting that when you ask a question, you raise your hand. You will indicate the media house you represent. Please try to be brief when you ask questions. We've allocated at least 40 minutes for this session, so it will be useful if the questions are brief and to the point. One question per person, we may take more rounds if needs be. I will see by the show of hands. I see one question as Ensol here. I don't see any other hand. I see Mr. Benjamin. I think we will go according to that order for now. Thank you very much. Please go ahead. Please proceed, ma'am. The person who appears as Ensol here, please ask the question. You are unmuted, but we can't hear you. May I proceed to Mr. Benjamin then, in the meantime? Begizeli Benjamin, yes. Please.
Thank you, Mr. Ncube, and thank you, Justice Zondo and Justice Lowe, for the presentations. Justice Zondo, I have two questions for now. The one is the question of finalization rate. I'd just like clarity on the time period in which the cases that are considered finalized are decided. Is it in reference to the norms and standards or by any other measure? And then secondly, in part of your presentation, you spoke about the court modernization, and you also made mention of the security breach on the IT systems. Can you provide clarity on how this affected the Superior Court judiciary, particularly in Gauteng, where the case-like system is already working, but also in the other superior courts? Thanks.
Thank you very much. Over to you, Acting Chief Justice.
Thank you, Nati. Let me say at this stage, as everybody has heard, we have got other members of the leadership of the judiciary who are here. And in terms of the question and answer session, I'm going to indicate when I would like other members of the leadership to also come in. With regard to when our matters considered finalized, that is when a decision has been made. That is, for example, if it's an application, if it's granted or dismissed, or if it's an appeal, it is upheld or disallowed. So it's the outcome, it's the final outcome that of the matter that one looks at. So a matter will not be considered to be finalized if it is just postponed, because that is not a decision on the actual matter, and that is not also a decision about jurisdiction or any matters of that kind. So that is when a matter is considered finalized. With regard to the security breach, although there was some disturbance, as I understand the position, the OCJ was able to move in and do the best it could to mitigate and try and ensure that the damage was not as bad as it could have been. With regard to modernization, the heads of court have a committee that deals with modernization, and I'm going to ask Judge President Mlambo, who is chairperson of that committee, to deal with the issue of modernization.
Thank you very much, Acting Chief Justice. I hope I'm audible.
Yes, you are.
Thank you very much. I think the question that was asked by Mr. Benjamin was the effect of the security breach that affected the Department of Justice, and I think you have answered it. But as the OCJ, we were never markedly affected by that breach because our services continued as usual. I did not understand the question to want more on the modernization aspect proper, although I can confirm what you said in your presentation, Acting Chief Justice, that we remain resolute in ensuring that we use modernization and we advance the South African judiciary on the modernization journey to introduce more efficiencies in our processes. Let me stop there. Unless I've left something else, I will deal with it. But thank you very much, Acting Chief Justice.
Thank you, Judge President Mlambo. I just want to add with regard to Mbegezeli's question about when matters are finalized. I just want to indicate that how the manner of calculating the finalization of cases is explained in the report at the end, where there are technical descriptions of indicators at the back of the report. So that can be found there as well. Thank you, Nati.
Thank you, Acting Chief Justice. Colleagues, we then going to try again.
Can I ask my question now? Sorry, previously I was muted. Can you hear me now?
Yes, we can hear you, Linda. You can go ahead.
Yes, thank you. Acting Chief Justice, I just wanted, there have been views expressed even by a former judge about the quality of the judges on the court. I'd like to get your view, please, on that, and whether you think that the existing process of electing judges through the Judicial Service Commission needs to be reformed in the light of the recent politicization of the whole process. Thank you very much.
Linda, can you just repeat the quality of what?
There have been concerns raised about the quality of the judges on the Constitutional Court as reflected in certain judgments. And this was a matter of concern.
Yes. Okay, we got the question. Thank you very much. Chief Justice, please allow me to take another one from Desiree Erasmus. Please go ahead, ma'am. I'll then come to Ms. Rapkin.
Thanks, Nati. Can you hear me?
Yes, we can.
Good morning to the justices. It's Des Erasmus for Daily Maverick. Good morning. We have seen unprecedented attacks on the judiciary this year and open threats on the Constitutional Court and its justices. I didn't, a cursory reading of your report. I haven't seen much on that. Justice Leo was talking about strategic plans for the judiciary. Will attacks or potential attacks on judges be included in this? And what is in place within the current framework to deal with the kind of threats we witnessed, for example, during the July riots? Or is it simply left to SABC? Thanks.
Thank you very much, Mr. Ezri. When we come back, we will take Ms. Sung Kim and we'll also take Ms. Rapkin. Thank you very much. Over to you, Acting Chief Justice.
Nati, is it Linda?
Yes, it's Linda Answer from
yes. I think she asked a number of questions, and she was quite fast. Maybe if she could just repeat, let me understand her questions.
She texted the question to us. It says concerns have been raised about the quality of some of the judges on the Constitutional Court. What is your view, and how can a high quality be assured?
Okay, maybe let me take some, and I will refer another one maybe to Judge President Leo, because there was a reference to her. The judiciary, including the judges of the Constitutional Court, appreciate that it's important to ensure that they produce quality judgments, and they most of the time get that right and produce judgments that are a product of hard work and a product of serious consideration. But of course, it will happen that from time to time, somebody will pick up some mistakes, but on the whole, the overwhelming majority of judgments that are handed down by the Constitutional Court are not judgments that have mistakes or errors. The judges continue to take various steps to try and ensure that there is quality assurance in terms of the judgments that they issue. What was the other question, Nati? The manner of appointment of judges?
Sorry, the other question was whether the acting Chief Justice believes that the process of choosing judges through the Judicial Service Commission should be reformed in the light of the recent politicization of the process.
Thank you. Over the years, there have sometimes been people who have expressed views about the need for changes or reforms to be made to the manner in which judges are appointed in South Africa. And certainly, I have heard of late some people who advocate that there be reforms. But I, at this stage, would not call for any reforms in terms of the constitutional arrangement. I think that it is more important that we try and not tamper with the Constitution unless really we get to a point where it's really serious. At this stage, I would not be calling for any reform in terms of the manner in which judges get appointed. Thank you, Nati.
Thank you. Ms. Yun Kim, please ask your question to be followed by Ms. Rapkin. Rapkin.
Thank you.
Thank you.
Can you hear me?
Nati, I'm sorry, Nati. I think there was a question that Linda had asked which related to Judge President Liu. One that I thought I would ask Judge President Liu to deal with. I don't want her to think that we are ignoring her question. I don't know if you remember it or they sent it to you.
I do not have that question, ACJ. Maybe, Linda, are you still there? Was there another question that was not addressed?
No, there wasn't another question. Thank you very much for those answers.
Okay.
Nati, it was me who asked the question about Judge Liu.
Okay, can you please repeat that for us, Desiree?
All of my questions were regarding the unprecedented attacks on the justices. and open threats on the Constitutional Court and its justices. And I asked that Judge Liu spoke about the strategic plans for the judiciary, and will attacks or potential attacks on justices be included in this? And what is in place within the current framework to deal with the kind of threats we witnessed on the judiciary during the July riots? Thanks.
Thank you.
Let me say something, and then maybe Judge presently you can also come in. You are right to say that there were threats made, security threats against the judiciary during the July unrest. The issue of the security of the judiciary was handled by the state, and there were discussions involving the leadership of the judiciary and the leadership itself conferred on what actually needed to be done. And at that stage, the measures that were taken were understood by the judiciary. Obviously, going forward, if there are further threats, security threats, they would need to be dealt with at that time. And I am of the opinion that the state would take measures to ensure that there is protection if there are threats against the judiciary. Judge President Leo, I don't know whether you would wish to say something.
Yes, the question was whether the security issues relating to judges are also included in the strategic plan. That is the draft strategic plan. I mentioned that with regard to that, the strategic plan is work in progress. And if needs be, the issue relating to security of judges may be included there. We have not had an opportunity to discuss that issue. This matter has been, or rather the issue relating to security was being handled by the subcommittee of the heads of court that deals with security for judges. Thank you.
Thank you, Judge President. I am going to ask Mr. Kim. I apologize. I said Ms. Kim. Mr. Kim.
Okay.
To take over, and then Ms. Rapkin to also come after Mr. Kim. Thank you.
Thank you. Thank you, Acting Chief Justice Zondo, for your presentation. I am a special correspondent from Korea, and when I saw this, the cases these days, South Africa has faced this kind of a strong, measure of lockdown. So how did you overcome it in processing this judgment compared with the period before this lockdown? How did you overcome it? Can you say more about that? And the second question is, how did you facilitate the gender-based violence judgment in these difficult times? Did you speed up the proceedings of judgment? Thank you.
Thank you very much. After the lockdown had been instituted, the judiciary, like many other sectors in business and in society, had to consider how it would operate under the environment of a lockdown and with COVID-19 that started last year. A decision that was made was to ensure that there would be virtual hearings that were conducted. Those have continued to a very large extent, and indeed, I think that the South African courts are getting used to virtual hearings. You may be aware, you may or may not be aware, that the Constitutional Court has been having its hearings virtually for a very long time since the institution of the lockdown. And the Supreme Court of Appeal also hears their appeal virtually. So that is what happened. But also the leadership of the judiciary issued directives to deal with issues of COVID-19 and the access of people to court premises and to courtrooms to ensure that there would be compliance with health protocols. But as far as the handing down of judgments, to a very large extent, it was based on virtual hearings. Thank you. I mentioned Nati. I mentioned the directives that were issued by the leadership of the judiciary. The Chief Justice issued directives and issued a directive that enabled judges president to also issue directives that would apply within their jurisdiction. And the OCJ arranged for virtual platforms that would enable the provision of tools so that there would be virtual hearings. There were computers that were arranged to enable all of this to happen. Wi-Fi was extended. Bandwidth also was expanded. There were ICT licenses that were arranged. So there was quite a lot of work that was done by the OCJ and the judiciary to make sure that COVID-19 and lockdown did not hamper access to justice more than it could be accepted in our country. So all of these measures were taken to make sure that the courts were able to proceed in the circumstances.
Thank you very much, Acting Chief Justice. May I first request Mr. Kim and Mr. Benjamin to lower their hands unless they intend to ask other questions. Ms. Rapkin, over to you.
Thank you so much, Nati. Good morning, Justices. I have two questions. Is that okay?
It is in order, ma'am.
Thank you. The first question relates to the reserved judgments. In last year's annual report, there was information given on judgments that had been reserved for longer than 6 months. I have had a quick look at this year's report and I don't see that information. What I see is judgments that have not been handed down within 3 months. Is it possible to get those that have been reserved longer than 6 months in the same way that we did in last year's annual report? That's the first question. My second question is that I'm looking here at page 9 of the annual report that refers to the elimination of a backlog on complaints to the Judicial Conduct Committee. I have had opportunity to look at the Judicial Service Commission's annual report for the same period, which doesn't mention this clearing of a backlog. In fact, I have a number of questions following up from the JSC's annual report regarding Judicial Conduct Committee, complaints to the Judicial Conduct Committee, and wanted to take the opportunity, since this is referred to in this report as well, to put them here. One of them relates to a complaint that was laid in January of this year against the Chief Justice, the former Chief Justice, about a prayer about a vaccine that apparently has gone nowhere. If I can just find out what happened with that complaint. In general, I wanted to ask the Acting Chief Justice whether the way in which these complaints are dealt with and reported back in the Judicial Service Commission annual report is fulfilling the legislative mandate of the JSC Act, in the sense that this is the first we are hearing about a clearing of a backlog, and we can't see from the JSC's annual reports the progress of complaints through the system, because all the annual reports say is that this is the number of complaints that have been received and these are the number that have been finalized in that particular year. It doesn't actually deal with the backlog, and this is my question: is why not, and whether this is what is conceived of and envisaged by the legislation. Thank you.
Thank you very much. With regard to judgments, they are published reserve judgments that are older than 6 months. They are published in the website every 6 months. So it ought to be possible for anybody to access them. So that information should be possible to find.
Thank you, Deputy Chief Justice. Thank you.
Yes. And then there was the question of what happened to the complaint that was lodged against the former Chief Justice. I don't have an immediate answer on that, but that information can be given to you after this by the Secretariat of the Judicial Conduct Committee. I know that generally speaking, the way in which or whatever backlog may have been there in regard to complaints against judges a few years ago, a lot of that backlog has been taken care of, and that generally speaking now, except maybe for a very few, generally speaking, complaints against judges get dealt with very frequently. One of the things that is responsible for that is that from about a year ago, the heads of court, the judges president, and other heads of court were involved. They got involved in the adjudication of complaints against judges, because many complaints against judges are really complaints that get disposed of without even the Judicial Conduct Committee asking the judge consent to comment, because a lot of them are just complaints from people who are aggrieved by the outcome of their cases. But of course, there are other cases that are certainly not frivolous and require proper attention. Thank you.
Thank you, SCJ. Please lower your hands, colleagues, if you have no further questions. I note there is Mr. Tseho Moahi who wants to ask a question. Before I allow him to speak, Acting Chief Justice, I've received a question from Mr. Vianney Green of SABC News. The question is, does it not worry the Acting Chief Justice the fact that the President is delaying to make appointments for the vacancies in the Constitutional Court, despite the fact that the JSC has submitted its recommendations as required by Section 174? The second question is, doesn't the delay by the President in making the appointment, including for the lower court, I assume is referring to the high courts, as advised by the JSC, fly in the face of Section 2 of the Constitution? This is from Mr. Vianney Green from SABC.
Well, let me take the first question about appointment, the filling of 2 vacancies in the Constitutional Court that I think Mr. Green is talking about arising out of the interviews that were conducted by the JSC at the beginning of October. My understanding is that the president is still engaged or has been engaged in the process of consultation that is required by the Constitution, and that process had not been finalized recently. It may be that it is finalized as of today, but I'm aware that it had not been finalized a while back. So I am confident that in all probability, the president would be making his decision known in due course. So the interviews were in October, and we have had November. We are early in December. Compared to other occasions which have happened in the past, I think we have had much longer delays. Based on my understanding of what is happening in terms of the consultation process, I believe that the president would be making his decision quite soon. The appointments of judges in the other courts, such as the various divisions of the High Court, I am not sure what the delay is, what is causing the delay, but I hope that the president will make the appointments without any further delay. Thank you.
Thank you, Acting Chief Justice. May I now hand over to Mr.
I'm sorry, Nati. May I just add some information to the question that was asked about complaints? I am looking here at the Judicial Service Commission annual report for 2020-2021 at page 13. It says, for the period under review, the committee received 162 complaints lodged against judges in the various superior courts. Of this number, 81 complaints were resolved, while 81 are still pending. In 2019-2020 financial year, the committee dealt with 99 complaints, of which 70 were finalized, while 29 were outstanding. The numbers reflected above indicate a 64% increase of the number of complaints received by the committee for the 2020-2021 financial year. So the issue of the numbers is dealt with in that report.
Thank you very much. Thank you, Acting Chief Justice. Ms. Tseho Moahi, I apologize. I said Mr. I apologize once more. Over to you.
No problem. Thank you so much, Nati. Good morning, Justices. You're saying in your report, Acting Chief Justice, that 11 judges were discharged from active service. Can you possibly give us reasons why they were discharged? And if it's for disciplinary issues, do we know, can you just let us know what exactly the reasons are for them being released from their service? Thank you.
Thank you very much. I think that the problem is the terminology. Discharged in the normal meaning would be understood by ordinary people to mean dismissed. But in the context of the judiciary, when a judge retires, for example, in terms of the legislation, you talk about that judge being discharged. So it doesn't necessarily mean that they've been dismissed for misconduct or anything of that kind. So when they retire, the term used is discharged from active service.
Thank you, Acting Chief Justice.